Thank you. I think, may I just invite everybody to take their seats, and also please, if I could ask you to move in so that any spare seats are left towards the aisles, and anybody who comes in late will then be able to slip in quickly to a seat. Thank you very much. And while you're all doing that, let me also say that I understand that Pragno in the previous session had referred to a slide, and this is it, up behind me, here, for those of you who were here earlier. So please, as I say, please do try to move in and leave some seats free. Right, so thank you very much, and welcome to this session on women in prisons. I am Aswini Weeraratne. I am a barrister at Doughty Street Chambers, and I have the honour of chairing the session. Now, in 2007, Baroness Corston reported to the Home Office on women in the criminal justice system. Now, at that time, she noted that the number of self-inflicted deaths of women in prison custody had fallen, and that in 2006, some 3 were recorded. She also noted that the provision of all types of health services within women's prisons had improved. Nevertheless, she concluded that the time was right for a radical change in the way women are treated throughout the whole system, including not only those who offend, but also those who are at risk of offending. She recommended a woman-centred approach, a fundamental rethinking about the way in which services for this group of women are delivered. And she made a raft of recommendations, including on resettlement, sentencing policy, and real alternatives to prison, seeking gender-specific approaches and changes to existing practice. In 2013, the chair of the Justice Committee, introducing the committee's report, Women Offenders After the Corston Report, said that the government's transforming rehabilitation reforms have clearly been designed with the male offender in mind. This is unfortunately symptomatic of an approach within the Ministry of Justice and National Offender Management System that tends to deal with women offenders as an afterthought. That report said that efforts to implement Baroness Corston's recommendations have stalled. Today, the Prison Reform Trust reports that women entering prison are more likely to have been in prison for non-violent offences, and women in prison are highly likely to be victims as well as offenders. More than 53% report having experienced emotional, physical or sexual abuse as a child. There appears to be widespread agreement as to what a system based on gender equality should look like. However, I should mention that the Howard League has just intervened in the case of Coll before the Supreme Court, which is challenging the failure to provide a woman released on life licence with appropriate accommodation in London near her family, due to the lack of approved centres for women and on the grounds of unlawful sex discrimination. The Howard League, in fact Francis Crook sitting next to me, provided evidence on the marginalisation of women within the criminal justice system generally, the particular disadvantages women face in resettling into their communities successfully, and some feasible alternative approaches. So now it is 2017, 10 years after the Corston report. Where are we now? We have 3 excellent speakers to address this question from different perspectives. Now, our first speaker is Francis Crook, and as I've said, the chief executive of the Howard League for Penal Reform since 1986. This is the oldest prison reform charity in the UK, having been founded in 1886. She's been responsible for many important campaigns and research programs to raise public concern about various prison issues. She has had a varied and interesting career, you will see from her biog in your packs, including having been a secondary school teacher, probably one of the most difficult jobs in the country, and a Labour councillor in Barnet. And she was awarded the Freedom of the City of London in 1997, an OBE in 2010, and she says, quite importantly, an honorary doctorate in law from the University of Liverpool in 2016. So everyone has 12 minutes. Don't forget we have a rapporteur. The brilliant Kate O'Rahilly will be noting down points from today, and also I've been told to focus your minds on action points. So with that in mind, I'm going to ask Francis to begin. Thank you.
you very much. Of course, the most important honour is the freedom of the City of London, which means that I can drive my sheep across the bridges and I can be drunk and disorderly without being arrested, though I have not tested either of those. As we said, the Howard League intervened in a Supreme Court case because we are not only a charity, but we're also a law firm, and I'm particularly pleased to get the honorary doctorate because I'm not a lawyer, but I do manage lawyers. We have a legal team in the office, and we do take test cases, and we do represent children and young adults in custody, as well as intervening in important strategic cases as they come along. So we intervened in the case which Ms. Cole. Because there is discrimination in the system. The criminal justice system is designed by men for men, and that affects women very badly. We also, as a charity, support the all-party parliamentary group on women in the penal system, which is chaired by Jean Causton. And we are currently looking at the sentencing of women, conducting an inquiry into sentencing of women. So as a charity, we do intervene in very highly political issues, obviously giving our expertise. Our view is that prison should be abolished for women, that we need to have a very few small units for the very few women who've committed serious and violent offences and from whom the public needs some protection. But you may be talking about 10, 15, 20 women, something like that, and abolish the rest. In the meantime, and that's my vision, our long-term vision, in the meantime, we must do everything we can to make the custodial experience safe, constructive, and kind. The women in prison are our sisters, but they are women who've not had the opportunity to organise or to flourish. There are around 8,000 women who are sentenced to prison each year, and the vast majority are sentenced to prison for very short periods of time, less than a year. Indeed, over half are sent to prison for less than 3 months. And we should be shocked about this. We should be shocked because 3/4 of them suffer from a diagnosable mental health problem. Many are drug or alcohol dependent. Many are victims of various different sorts of crimes, often, of course, domestic violence and abuse and sexual assaults. Now, the landscape in criminal justice, in prisons, but also in the wider penal system, changed when Chris Grayling took over, who is actually Darth Vader. He did nothing good, and now he's, in charge of transport. He introduced an additional punishment so that anybody who got a short prison sentence would be supervised for a whole year. So if you go into prison for 2 or 3 weeks, you get a whole year's supervision. And if you fail to comply with what you are told to do, you get recalled to prison. And of course, this is really affecting women very, very badly. You say get back to prison for up to 14 days, and so far over 1,000 women have been recalled to prison, many of them more than once. This is inflating the number of women in prison who are there for very short periods of time. I have to admit that prison conditions actually are not as awful for women as they are for men. But that is not because they are good conditions, it's because the conditions in prison for men are so utterly awful. It's so violent and so dangerous and has been deteriorated so badly, which again is all Chris Grayling's fault. Prison is not a healthy place to thrive in. You are considered old at 50 because the environment itself is so toxic. And in prison, women are treated in many ways worse than men because they are punished more for misdemeanors inside prison, for disobedience. I love that, punishing women for being disobedient, or disrespectful, or for having unauthorised transactions, and occasionally for violence, although actually very rarely. And I think the higher punishment levels for women in prison actually exacerbate and make worse the higher incidence of self-injury. Because if you take away from anybody, but from women particularly, the power to vent frustration externally, they can only internalize it. So if you punish them for externalizing and for being angry, they take it out on themselves. And it causes more misery and therefore more self-injury. So the women's prison population is a demography of distress. And the numbers of women sent to prison has exploded in the last 10 years. The failure of the system is really a failure in the community. It's our failure as a whole. And the answer has to be in the community. Jean Corson's report, which was already been referred to, 10 years ago looked at the deaths of vulnerable women in prison. But and it was based in tragedy. However, there was something good that came of her report. And there's not often a good thing that happens in the criminal justice system or the penal system. But generally what happened as a result was the establishment of women's centres. And the all-party group which she chairs published a report on women's centres, and there's copies of it at the back. The Howard League no longer publishes great thick reports because nobody ever read them and they just sat in a cupboard in my office. We now publish very short briefing papers with a synopsis on the front and a press release, because that's the way you get issues across to people in the Twitter age. So if you look at the report, what we found was that there are around 50 women's centres. Now, many of these women's centres grew out of the 1960s feminist, second wave feminism movement, but increasingly took on contracts to provide other services, both for local authorities, for domestic violence or health service or whatever, and recently took on providing supervision on things like court orders. But the most important thing about the women's centres is they're all different. They all do different things. And they see the woman, they put the woman at the heart of what they do. So while they're delivering a sentence, actually, it's a wraparound service. It's a one-stop shop. It literally means that women get a hug. It's a safe space. Women can learn about how to put together a CV, about how to get a job, about how to get away from abusive relationship, about how to get off alcohol or drug dependency. They can learn to cook. They can learn about debt, how to get out of debt. They can be helped to get housing. They can be helped with their childcare or other caring responsibilities. They can get training to do a different sort of job they haven't thought of. They can have reading groups. They can do all sorts of things in these places, and they are incredibly successful, unlike the prisons. Now, the problem is that this great success story, which, as I say, is extremely rare in the penal system, is under threat because of the system set up by the privatisation and the dismantling of the probation service. Grayling set up something called Community Rehabilitation Companies, CRCs, 21 of them, 21 areas, and they commission resources in the community. I'm a bit geeky and it's structural, but it is incredibly important, because what it means is that they then are responsible for the funding for any community services or voluntary groups or women's centres. And many of the women's centres are saying, no, we're not going to be contracted by the CRCs because they put in things like gagging clauses. So the women's groups are not allowed to criticise what's going on. They will only pay for group work. Well, vulnerable women don't necessarily want to work in groups. They need one-to-one. Sometimes they can work in groups, but sometimes not. You have to do whatever's appropriate. Group work, of course, is cheaper. Simple. It's not necessarily more effective, it's just cheaper. And they can tick the box of, we've delivered a service to 25 people or 500 people or whatever it is, because that's the way it works. So a world-class service is being destroyed by private companies. And choices made by a career politician who walked away from the shambles he created and the damage he inflicted. Briefly, for the future. The Prisons and Court Bill is actually quite anodyne. There's nothing much in it. But importantly, it says nothing about women. We must stop the recalls to prison because that affects women, and my charity, the Howard League, will be working on that. In fact, we've just written to the Secretary of State about it, and I've asked for a meeting. We must protect the women's centres, and Jean Corsten and I are going to be doing some work on that. We must recognise that women are different, that women do not commit offences of random or premeditated violence. It's extremely rare. There are 85,000 people in prison. 81,000 of them are men. The system is designed for men, but also women are different, and we need to recognise that. Women's offending is almost always linked to poverty, ill health, abuse or exploitation. I am not denying a woman the right to be a career criminal if that is her choice. But it is unusual. We must treat women differently. And we must not be afraid to say it. We are different, and therefore we deserve different responses. And finally, I wanted to ask you to do something for me. I want you to wear red on Wednesday. You all know about that? No. Wear red on Wednesday. It's a big international thing to show support for women, following the Women's March. And many women are going on strike to show how important women are across the world. But wear red to show support. Thank you very much.
Thank you. Well, thank you very much to Frances. And also, I didn't have to use any of my little wavy things at all, which is even better. So, thank you. Our second speaker, you will hear from Jane Ryan. And Jane is a solicitor at Batt Murphy, which is, of course, a firm that is preeminent in prison law. And Jane specialises in human rights for prisoners, public law, and those detained under immigration powers, and has worked with transgender people who have been mistreated in police and prison custody. She was shortlisted for the Public Lawyer of the Year award at the Legal Aid Lawyer Awards last year. And today she's going to talk to us a little about, from her own experience and her casework, and one of her clients with a history of self-harm recently been before the parole board, and other things as well, no doubt. So thank you very much, Jane.
Thank you. I'm going to try and balance my Mac here. So before I start, I wanted to give two caveats. One, in that this isn't really a legal talk, so the legal experts in the room will have to bear with me. It's more of a rant about the things that trouble me. I'm also going to focus on sentence planning issues. So this is sentence planning within prisons. It may sound boring, but as a prison lawyer, it's one of the most fundamental things that you deal with. And I would say it's one of the most depressing things that I deal with, is seeing the difficulties that people have in getting into a position where they can be released. So looking at the wider context, going back to the Justice Committee, the follow-up to the Corsten report, what that said was really just a direct quote. It's also now well recognised that it's not permissible for women offenders to be dealt with in the same way as men. And so going back to what Frances is saying, what we see there is a recognition that different approaches must be taken for women. And I would say that includes women who've been convicted of violent offences. So I want to talk about one of my clients. So she was convicted in 2006 of attempted robbery, basically a mugging. She attempted to steal a handbag. She was a teenager at the time. She was homeless. She had a drug habit, and she'd been the victim of physical and sexual abuse since she was 6 years old. At the time of the offence, she'd just left an abusive relationship. Now, as she had one similar previous conviction, the court determined that she posed a risk of serious harm, and at that time was required to impose an indefinite sentence of public protection. So the minimum terms, that's the time that she was required to serve before being eligible for release, was 2 years, 2 months. 11 years later, she's still in prison. She is 9 years over tariff for an offence that, although serious, is not on any standard the most heinous. Now, thankfully, the IPP sentence was abolished in 2012, as I'm sure many of you know, and that was partly due to the abject failure of the criminal justice system to cope with the explosion of indefinite sentences and allocate resources so that prisoners could demonstrate risk reduction. But 4,000 people are still inside, still serving IPP sentences, and they're not going to be released until the parole board decides that it's no longer necessary for public protection for them to be detained. Now, I did read one of the Howard League's big reports back in 2007. Thank you. And what that said was that for IPP women, the situation was more dire than for men, because the prison system was unable to invest adequately in the specialist assessments and support structures necessary. So as a direct consequence of insufficient resources being invested, women who were serving short tariff IPP sentences were the group least likely to be released on tariff expiry. Now, in my client's case, there are many different facets to her case, not all of which I can say is the fault of the state. But one issue was the approach of her offender manager, who took an Orwellian approach, saying my client is too high risk to be released, but too low risk to meet the high risk criteria for an approved premises, and therefore can't be released. And I look back at this, and there was an inspectorate report in 2011 looking at alternatives to custody for women. And that said, despite efforts to look at gender-specific interventions, some offender managers working with women demonstrate a lack of empathy towards them and didn't have the knowledge to work with them effectively. And this seems to be borne out in my client's case. In my own experience, I have found myself wondering on occasion whether my women clients are dealt with more harshly within prison because of their non-conformity to gender roles. We've heard about the excessive disciplinary processes, and I definitely agree with Francis that that's also my experience. I know of a private prison last year that refused to release a pregnant woman on HDC because they didn't consider pregnancy was an exceptional circumstance, even though this meant that the baby's first few months were in custody in prison. So going back to the IPP case, for her, overridingly, prison does not, has not, and will not work. In my view, her needs are just too complex for the prison system. She's a prolific self-harmer. She has an awful history of abuse, really awful. And there is evidence that being in prison actually made her worse. The fact of being in prison was detrimental to her. It elevated her risk of self-harm. She was hospitalized. She deliberately cuts her arteries, and on one occasion was close to death. And so we've heard about the self-harm issues, and I'd just say in 2015, there were 12 self-inflicted deaths of women, which was double the previous years. And I know there's one prison, HMP Foston Hall, again in 2015, that had 4 self-inflicted deaths. So you tend to get systemic problems within specific prisons, and that was subject to an internal investigation by the Secretary of State. So at my client's parole hearing a few weeks ago, we had to adjourn it because the risk management plan wasn't complete. The private contractor that had taken over mental health services at the prison hadn't met with her. There was no referrals to community mental health. Probation hadn't got a place in an approved premises. And there was no involvement of social services, which there needed to be because she has children. So basically, it was a fat mess. So at the hearing, so the judge, you'll be surprised to know, was a white man. But he gave up running. I shouldn't be mean about him, so he was actually very good. But he gave up running the hearing and instead held basically a roundtable conference, so where all the different agencies sat round and talked about what should have happened in her case, what needed to happen, and how she could be supported in the community. Now, obviously, in that case, it's shockingly late, but I do think that that type of innovation, of getting agencies together, is very important, particularly for complex cases. So then thinking about the question that we're looking at today, so what more can the law do? I think I need to be careful because I'm not criticising public sector workers, because I've seen many people working with women offenders that work very hard because they care about the people that they're working with. But clearly in this case, there's a total breakdown of the criminal justice system, from the lengthy and disproportionate sentence at the beginning to failures in enabling release 11 years later. So who is responsible? In this case, the parole board was trying to bridge the gap, belatedly bringing people together to provide a supported community plan. But without oversight, those different agencies won't work together and needs won't be met. In my view, the case shows an alarming lack of oversight by the Ministry of Justice, who, let's not forget, is the detaining authority. She has to have her case reviewed every 2 years, and even though she's refusing oral hearings before the parole board, no interventions were made by the Secretary of State. So the Secretary of State is happy to ignore problematic people within her care and leave it to overwhelmed prison staff to try and muddle through. This case may be a further argument in favour that the powers of the parole board as the independent body should be formally included as part of the court and tribunal service, with the extension of the parole board's powers and further active case management be a means to addressing some of the issues in this case. I think it probably would. It would have helped. But what about the cases that aren't parole cases, the cases that don't engage Article 5? Those people, those women, still need active sentence planning, and they still need help in providing a supported community release. Now, we've heard about Liz Truss's proposals, and I agree there was nothing new there. But what she did say is that in an amendment to the Prison Act, under the new Prison and Courts Bill, that will, for the first time, it says, enshrine in law, reforming offenders as a key purpose of being in prison, and that the Secretary of State has responsibility for delivering it. So would that have helped my client? Again, I'm not sure. The state does own non-delegable duties to people within its care, and it's obviously not acceptable for people like my client to fall through the cracks. There should have been proper oversight from the beginning to the end, and contracting out services doesn't end that obligation. But that responsibility can only be discharged through proper investment, new training and different approaches. We've seen before with IPP that without investment, resources and training, the system will completely fail. So thinking about taking a gender-specific approach, so pushing the law to provide real, tangible and protective rights for women in custody, the amendments to the Prison Act that have been proposed about introducing this aim to reform offenders seem to be welcome, but it's very unclear what it means or how it will work. If it's just going to be a new level of bureaucracy or criticisms of governors, then it is not welcome. What would be welcome is early intervention, proper sentence planning by relevant agencies at an early stage, and with a view to sort of preparing supported release, rather than having inflexible policies that are driven by headlines. On the Cole case that we've heard about, I think there is one important point on this, which is that Mr. Justice Granson, back in 2013, found that the Secretary of State had breached the public sector equality duty, in that he, at that time, hadn't had due regard to the needs of women in relation to the provision of approved premises PACEs. And since that time, the Secretary of State has done nothing about that. And that in itself shows an issue, because what the Secretary of State needs to do is ask herself those questions and delve into the evidence about the problems that women offenders have, the problems that inadequate provision gives to women, their families, and rehabilitation. So sort of trying to bring it together, I think obviously there's a fundamental question, which is, advocated by the Howard League and others, which is there going to be any change without reducing numbers? That's the key issue with prison. We know that 81% of women inside are convicted of non-violent offences. And I would say that we also know that the interventions for violent and more serious offenders need to be gender-specific. None of this is news. So the real question is, why hasn't the Secretary of State listened? She needs to listen, engage with the body of evidence before her, and implement meaningful changes, rather than introducing headline-grabbing league tables. I've seen far too many people who are in prison for too long because of a panicked reaction to crime, and there needs to be a much more radical approach. Thank you.
Thank you very much, Jane. Our third speaker, I'm delighted to say that Eulalie Burnham is a colleague at Doughty Street Chambers. She's a specialist in mental capacity, mental health, equality and human rights law. She was formerly the chair of the Discrimination Law Association and has written extensively on the public sector equality duty. She is a committed and passionate writer and speaker on gender and race issues. She has acted for transgender prisoners seeking to enforce their rights under the Equality Act and spoken widely on the issue of trans equality in the prison system, which is what she's here to speak to us today about. So Eulalie is going to address you from her chair over there. Eulalie, thank you very much.
You. I hope... Can everyone hear me? I'm sorry to remain seated, but I think I've already got too much chaos in front of me, and I think if I try to transport it to the lectern, it won't work. I'm just want to start by saying I'm really pleased to be here, and despite it being a Saturday, and to, if you like, focus on this issue for the purposes of International Women's Day. It seems to me that one of the things, certainly, that I have found in looking at the issue of trans rights generally is that it helps us to think through things that both the civil rights movement and the feminist movement in the last half century have been trying to achieve. And in some ways, and it's important to include all different, or to think about these categories in a less restricted and binary way, so be it women, be it race, whatever. And in some senses, what feminism has done for us is to start or chart the course for challenging the notion of women's roles, particular kinds of female behavior, male behavior, etc. And what, in a sense, the civil rights and critical race work has done for us is to start to help us to look theoretically and practically at discriminatory disadvantage by virtue of categories such as race and ethnicity and so on. And what, in a sense, I think the trans rights movement does, and I'll come on to prison in a second, is that it allows us to talk about the damage that these categories themselves create. And it takes us to what perhaps seems like the natural end point to the kinds of historical struggles I'm talking about, in that it begins to challenge the categorization itself. And it seems to me that that is why talking about trans women in the context of an International Women's Day panel is quite important. And one of the reasons that talking about trans women in prison is important, it seems to me, is that, as Frances and Jane have said and know from their work, prison in itself is inherently violent. And in a sense, the use of force is elemental to the function of the prison system. If you can't coerce or use force in prison or threaten the use of force, it doesn't work. So once you start to think of a system that is principally based on that, you realize that those who are going to be vulnerable within it are going to be women, who are to some extent vulnerable in terms of, in that sense anyway, and then those who are subgroups of women who face other stigma and other forms of prejudice are going to be even more vulnerable in that category. And that's why I think looking at the issue of trans prisoners is something that's quite important. So what happens to these categories of person when they're subject to the overweening power and control that is exercised within the prison system? And in a sense, one of the things that is interesting, I think, is that it's the trans activist or movement that has been at the forefront of the campaign for prison abolition, but that's probably a bridge too far for today's purposes. So in a sense, one of the things about trans rights, I think, is that it allows us to think about those categories that, of the in-between, about the not quite and the not right. And it's interesting because trans rights, in a sense, it's those of us who would like to think of ourselves as human rights practitioners, there was a watershed that started with the case of Goodwin in the UK, and that was a case about where the trans person involved was able to ask and obtain recognition, for legal recognition really, for the move from her birth gender to what would now be termed the affirmed gender. And the thing about trans rights as well is that it's the nomenclature is vexing, because there is so much that one has to learn, and I certainly have had to learn. But in any event, what I found significant is that Goodwin, one of the things that was said in Goodwin, which is really interesting in terms of the way the movement has developed, is that in Goodwin, it was said that in the 21st century, the right of transsexuals, and that again is not appropriate terminology these days, the right of transsexuals to personal development and to physical and moral security in the full sense enjoyed by others in society cannot be regarded as a matter of controversy requiring the lapse of time to cast clearer light on the issues involved. In short, the unsatisfactory situation in which post-operative transsexuals live in an intermediate zone as not quite one gender or the other is no longer sustainable. And interestingly now, the very thing to which many young people in particular are aspiring is to live precisely in that intermediate zone. They don't want to be one or other gender. And that's, so in a sense, turning sharply to the prison issue, it's the problem of the binary that causes problem for transgender persons in prison. So I'm not going to have time, obviously, to talk extensively about this, but I just wanted to talk about sort of two main issues, which is, and they are, the first one is that we had, before 2016, when a new prison service instrument was released, we had the 2011 prison service instrument, instrument or instructions? Instructions, sorry. And that, in a sense, was what set out national prison policy in relation to transgendered persons. And there were some really serious flaws in it, and some of them have been corrected, but Jane will probably talk a bit about what's still wrong with the instructions. But in particular, this was one of the things, and there was, many of you will remember there was a Gender Recognition Act in 2004, by which, and there were set out processes within that statutory provision for people who wish to have to reassign their genders from the birth gender to another to a gender they were happier to live in. There was a process by which one could do so and obtain a gender recognition certificate, and that process also involved having it, if you like, certified by a medical practitioner after a medical process was undergone. So that was the means of obtaining that. And that entitled one to the rights which derive from the Goodwin principle, which is that if you are living in your affirmed gender, you're entitled to be treated as so doing. And so the GRC was meant to say, here it is, I'm entitled to live as a woman if that's the the form of gender identity I choose, and I've done the relevant things to achieve it. Now, the difference was that the Equality Act did not require there to be any medical process or any signing off by any, great paternal figure of one's right to live in the gender of one's choice. So what the Equality Act did say was that, just bear with me for 1 second, that if you had the protected characteristic of gender reassignment, which again has fallen into disrepute, because I really don't understand why you would have to have a protected characteristic called gender reassignment. But if you had that protected characteristic, if you were either proposing to undergoing or had undergone the process for the purposes of reassigning your sex by changing physiological or other attributes of sex, then you were entitled not to be subject to discrimination that was prohibited by the Equality Act. Now that did not require a medical process. So if, for example, you were simply living as a woman or living as a man, if you were born as a woman, then that was enough to afford you the protection of the Equality Act. Problem with the Prison Service Instrument in 2011 was to some extent, it conferred rights upon prisoners by virtue of the possession of a gender recognition certificate rather than by virtue of the rights to which they were entitled under the Equality Act. So you had this kind of weird dissonance where sort of male to female transgender prisoners would be told, well, you can't actually, we're not going to send you to the female estate because you don't actually have a GRC. Now, that wasn't the law, but that's how it worked. And the other problem was that there was this exception within the Equality Act which allowed, and this, when I came upon it, I thought it was the most bizarre exception I've ever read. It says, it's in paragraph 28 to Schedule 3, and it basically allows the public authorities to if you like, to call what they are doing, or it prevents the acts of a public authority from being discriminatory if it is done if it is a proportionate means of achieving a legitimate aim. It doesn't say what the aim is and what the means are, but the matters to which it is directed in relation to gender reassignment are the provision of separate sex services. So what you knew right away, or the hint was, in single sex service provision, you can exclude transgender persons once the conduct in question is a proportionate means of achieving a legitimate aim. So it didn't say because of risk, because of anything. So what was happening in the prison estates is that basically the Equality Act certainly was not preventing prison, those responsible for locations in prison, from saying, well, we're not going to move this trans woman to the female estate because we've got a good reason and it's a proportionate means of achieving a legitimate aim. Okay, so anyway, in essence, what this all boils down to is that there is a new prison set of prison service instructions, which to some extent corrects some of the things that I was talking about. Now you have the term transgender is used rather than gender reassignment. There is now a requirement for there to be a transgender case board, which has to be organized 3 days after the initial reception into prison. And so some thought the authorities now have to think about where they locate people. And it's also, what is quite clear is they're underscoring the entitlement to live in the estate which accords with your affirmed gender. And it also makes clear that decisions not to do so must be risk-based. So I think I really haven't got much time to deal with much more of this, but I want to say one more thing, if I may. And it's that, having said all of this, it seems to me there's a move in the right direction. There's a move towards away from thinking of things in terms of the binary. And it's quite interesting to read a prison service instruction which talks about gender fluidity. But so this concept is translating its way into public policy. But there remains questions of risk. And these are issues that concern those who are responsible for dealing with risk issues in prison. Because what do you do, and I throw it out there to close this discussion, what do you do, how do you manage the issue about those, for example, who have committed serious offences against women and managing them within the prison estate, and doing so without basically making the decision on a prejudicial basis of simply not wanting to house trans women within the women estate, but looking more carefully at the risk factor and profile of those people. How do you devise the prison, or what we need to work towards is devising risk assessment systems which take, if you like, the discriminatory feature out of what has been a discriminatory system. Anyway, that is, I think.
Thank you very much. Thank you very much. Right, thank you. We are, I'm told, running over time, and I think it's because my clock is slightly different to the one on the wall. But never mind. So I'm going to say there are 5 minutes for now. So throw this open to the floor. Try and keep your questions and contributions brief, of course, and introduce yourself at the same before you make your contribution. It might be easier if we take, say, 2 or 3 questions at a time. So please put your hands up if you've got a question now. So let me see who would like to ask a question. And Kate, the lady on your right.
Hello, thank you. My name is Julia Wookie. I'm a solicitor. I used to do prison law, so this is all very interesting. My question is to you, Frances, about the proposed abolition of prisons, which I completely agree with, for women. My worry is that would there be a potential undesired knock-on effect that women could find themselves in pressured, if you like, by men or gangs to commit their crimes for them because they're safe in the knowledge that she's not going to be going to prison. So essentially placing them in more danger in society.
Okay, and the next question, please.
Hi, my name is Sneha. I'm from the Air Centre. How can we address the lack of empathy within institutions like the Home Office making decisions against victims of domestic violence or human trafficking and deporting them on these types of cases? So what would you recommend as a good way of telling them stop, don't make these decisions, essentially?
Okay, shall we take one more?
Hello, my name's Helen. I'm from UCL. I was wondering what the proportion of females in prison who are single mothers and how their child being taken away and put into care will affect them and the child's future.
Thank you. So we've got 3 very good questions there. I wonder whether we might ask Frances to kick off with the first one about the abolition of prisons and the pressure on women, the danger that might cause to them.
I hope not. Women do get bullied, and violence is used against women to commit offences. For men, carry guns, carry knives, as drug couriers. I don't call them mules, I think that's offensive. So women, that happens anyway. I tend to think that prison is not a deterrence to anything, that it's the getting caught that is the deterrence. And that works both for people who are middle class and who lose a lot, but also for people who are trying to persuade or bullying other people to commit offences. So if you think that somebody's likely to get caught, then you won't do it. And I think the case for prison abolition for women, and I might say for men too, but I think it's easier to achieve for women, is just unanswerable. I hope that Liz Truss, being our first woman Lord Chancellor and Secretary of State, will do something about it. I haven't seen any indication yet, but I'm always optimistic.
Thank you. So before we move to the second question, I wonder whether, as a sort of transgender perspective on that, Eulalie, in terms of the abolition of prisons.
I mean, as I said, I think the trans activism movement, and certainly the bits of research and work I've read, which comes out of the US and Canada, as far as I can tell, in the main, has been, you know, quite central in the abolitionist movement. I mean, I don't think they would make a distinction between women and men, not because it's trans activism, but simply because their focus is on what they say is it's a cruel and inhuman system for human beings, period. But I don't think, as Winnie, if I understand you correctly, that there is a transposition on the abolition, on prison abolition. I think it's genuinely their concern is trans persons are most vulnerable, particularly trans persons of colour, and it's quite interesting on intersectionality in that connection, but that are most vulnerable within what is already an inhuman system. That's how they would put it, I think.
Okay, thank you. So the second question came from the Air Centre, and it was about the lack of Home Office empathy for victims of trafficking and deportation and deporting profiles. I hope I managed to summarise that. I don't know, Jane, is that your area?
Well, kind of. I wasn't expected to talk about the Home Office today, but I'm always happy to have a go at them. I mean, what I would say is they operate on a level of suspicion for everybody, and they think everybody is lying. So it's not gender specific. But I did a case for a victim of trafficking and who was sort of forced into sexual exploitation by her husband. And the way that we won that case was by supporting what she was saying with independent evidence from a psychiatrist and through a scarring report. And it's only by having independent evidence that you're ever able to, I mean, not that the Home Office, eventually they conceded, but we had to go to court to win the case. So in terms of a kind of wider position about how do you change the Home Office's culture, I think it needs to be attacked by feminists and women's groups, because the change needs to come politically, because I don't think it's going to come internally.
Okay, thank you. We do have one last question before we go ahead. No, we have from the previous round. We had a question about single mothers and the effect on the mother and the child of separation. I don't know who wants to answer that question. Frances, do you think you could?
The Hadley's done quite a lot of work on mothers in prison and mother and baby units. And my view is that you shouldn't put babies in prison, so you shouldn't put their mothers in prison. It's very simple. I just think there are a lot of single mothers. There are a lot of mothers who, of course, the evidence is also that if you do have children, there's no one to look after them for you. Many women who do have young children won't tell anyone that they've got young children when they go into prison, because they don't want them to be taken away. They don't want social services involvement. So whilst we estimate there are many thousands of children who are affected by the imprisonment of a woman at some point during the year, nobody knows exactly how many. And actually, I think that's right. I would be totally opposed to forcing a woman to admit if she's got children outside. And mostly they do make their own informal arrangements. But our view is very much don't send women who've got caring responsibility. Well, don't send women to prison. Just stop sending women to prison.
Thank you.
They're not dangerous. Many of them are very annoying. I admit that. We can be annoying, but they're not dangerous. Women do not commit serious and violent offences. They are not dangerous.
Thank you. Now, I know we're under some time pressure, but I can't deny Helena her question because she stuck her hand up.
I've followed the transgender issue very closely, because I, in fact, did the first case. I mean, before the case in the European Court of Human Rights, we did a case in the European Court of Justice, which was on employment, where a person who was had been born male and was transitioning to female and was sacked. I mean, basically not sacked, but there was constructive dismissal. We don't want you front of house because we don't want people to see you, and you'll make us a source of ridicule. And so we fought it on the basis of constructive dismissal. We took it to the European Court of Justice, and we won the case. And it started a sort of move. It was a case of REP. But so I followed it very closely, and I really want to commend the work that you're doing. But the real problem in prisons, and this is internationally, is much less so about for transitioning male to female, because women are much more, I have to say, empathetic. When transitioning people go into the women's prisons, they're usually received with warmth and not don't suffer in the way that it operates in the other direction. When there's a transition from female to male, the idea of exposing those people to the male prison, which is so much more violent. I mean, Frances is nodding. That's where there are real challenges to the prison system, because men dealing with someone who's transitioned from female to male is so vulnerable within the male prison system.
Yeah.
Okay.
Thank you, Helena. I mean, that is a useful reminder to point up something about the new prison service instructions, which is that female to male transgender prisoners can stay in the female estate. They can opt, and that has to be respected if they make that option. It doesn't work the other way. And so I think that there's very much a sense in which this is true. And also, no one's sort of clamoring to keep female to male transgender persons in the male prison in the same way as they are trying to keep, as it were, let me just make sure I got this right, as they're trying to keep certain male to female transgender prisons in the male prison. So the real issue in terms of location, it seems to me, is the location of trans women, many of whom are housed on the male estate. And so that's, I mean, I'm not aware, maybe Jane can help us, but I'm not aware of precise problems before this new instruction about, I mean, I'm not at all, I agree with you totally, Helena, that obviously it is risky for female to male transgender persons to go into the male estate. I'm not aware of problems arising, certainly in litigation, about that.
Okay, thank you. I'm going to really draw this to an end now because we have run out of time, and we can take this conversation, I know, into the lunch section. But so first of all, there are two things. First of all, let's say thank you very much to our three wonderful speakers.